Morning, everybody. This is Marty from Dogs Blog in the Noontime Report for the Frank Carson et al. Trial. We're doing a motion today on October 16, 2018. We're doing the mistrial motion in regards to Jim Cook information and everything that happened there. My understanding was court was supposed to occur at 9 o'clock this morning, but it actually was rescheduled, I think, for 9:30, and then Judge got on the bench around 9:41. Judge Zunita also noted that when the DA had sent some case law last night and advised her that it should have been sent much sooner, and the defense attorneys agreed, as they were not able to read it all because they didn't not receive it timely. And then she was looking for some of that information on her phone up at the bench, and had to go back into chambers to look on her laptop. The mistrial motion was started. Percy Martinez argued the issue is Jim Cook was cross-examined for around 12 days during this trial. This was happened in August of this year. There was much focused on the methods that he used, using a protractor and eyeballing all the diagrams. This motion is in regards to mainly about the Southeast Turlock cell tower in the Southeast sector. The diagrams include the Frank Carson property in the sector, but there was not any precise software that was used. He only used protractors. Jim Cook testified he never used any type of specific precise software like Google Maps. But he had used and sent the two maps to Marlissa Ferreira on August 21st, 2018, which proved the Frank Carson property was outside the sector and was about 3 degrees outside. The program is incredibly much more accurate. When Jim Cook ran the maps, he was still under cross-examination on he ran them on 8/21 of 2018. He was on cross-examination on 8/22 of 2018, and he still said he had not used Google Maps. Said he was asked specifically if he did. He said no, and Marlissa Ferrer was in possession of those maps at that time. He says this is Brady information, and it impeaches Jim Cook, shows his inaccuracies, and Marlissa Ferreira never said a word or informed the court the entire day on the 22nd. Jim Cook was done that day to the glee of all. He said that, to the glee of all. And then the next day Jim Cook was here, to everybody's surprise, in the morning, and Marlissa Ferreira had arrived about a half an hour to 45 minutes late. DA had called him back and turned over the diagrams from 2 nights prior. Marlissa Ferreira admitted receiving the diagrams on the 21st, which was 2 nights prior, and shows does not put Frank Carson property in the sector. Marlissa Ferreira admitted in court of the information, but did not disclose it until the next day on August 23rd, 2018. The defense had every right to cross on that information. Marlissa Ferreira had a duty to disclose. Defense is entitled to that information immediately, and the DA deliberately withheld this information so the defense could not cross-examine effectively. The DA had a duty to disclose. Percy went on to say the DA also had not testified truthfully, had an obligation to, if somebody's not testifying truthfully, and allowed Jim Cook to testify untruthfully. Defense also advised the court that Jim Cook may need an attorney because of the possible perjured testimony. And this was said in the sidebar. It is on the record. One of the defense attorneys made that motion. He said Marlissa Ferreira committed a fraud on the jury and the court. All Jim Cook's previous diagrams would be subject to credibility with this information. Marlissa Ferreira turns to blame the defense or the court on these things when she has initially withheld. There's been a history with her. The information should have turned over the first thing the day before. Marlissa Ferreira did impair the defense's ability to cross until the next day, amounts to outrageous misconduct. Attorney Hans talked about August 21st, 2018. Marlissa, at 7:58 p.m., Marlissa Ferreira received an email with in the narrative side part of it that said, "Here you go," containing two maps that have shown a sector. Two maps that show the sector that's in dispute that does not cover Frank Carson property. On 8/22 of 2018, defense finished cross-examination of Jim Cook. As noted, the DA did redirect on Jim Cook and asked him, and he said, "No, sir." Jai Gohel had asked him if he had used the Google Maps, and he said, "No, sir." At that response, shows perjury and it's misleading, and Marlissa Ferreira wanted the defense to stay away from that area with constant ongoing objections. Then in the afternoon, Marlissa Ferreira redirected on 8/22 of 2018 in the morning session. Jim Cook was asked about that map software. It was clear in the cross that Jim Cook saying the Frank Carson was included in the mapping. They talked about Christine DiFilippo's device was vacillating between sectors. Marlissa Ferreira and Jim Cook go back to the office and tried to do mapping, and then Jim Cook went home and ran the maps for her and emailed them to her. Marlissa Ferreira realized that the information did not support her position, so she did not bring it up the next day in court. Defense cross was obviously insufficient without that information. Jai Gohel asked Jim Cook specifically if he had used the maps, and he said no. And the DA who received those maps the night before, about 14 hours earlier, said nothing, in fact objected instead of admitting to the possession of those maps. He says Jim Cook clearly misled the court and that he in fact lied on the stand. Marlissa Ferreira could have asked to approach the bench but did not. Maps could have been turned over then. DA said nothing. The impact on the jury is obvious, but the information not turned over until the next day. The jury is fed up with Jim Cook when he was done testifying, as the gallery was too. And he said the jury actually reacted in a relieved manner. The situation, he says, was so inappropriate what had happened with this mapping. Jim Cook had lied many times on the stand and said many times, cannot answer question as posed. Jim Cook says the mapping is a result of the CDRs. The impact is dramatically lessened by day. As the DA turned over the mapping the next day, the impact was lessened, and the court should have been notified on the 22nd. Jai Gohel argues this needs to be put in context. It was Brady information. The angle of this particular mapping had been scrutinized by the defense exclusively on every map. The maps looked off. They were obviously just looking at them. They looked off, and they varied. And they showed the jury that they varied. On recross, the defense asked about Google Maps usage. Had that showed when the DA tried mapping and that is why they went to map at their office, and it didn't work at his office. So he went home and used the Google Mapping to send to her in an email that night. Jim Cook continually said on the stand that he just used a protractor and he eyeballed it. He says, previewing testimony of Robert Woody and the property involved, meaning there's the theory of on Frank Carson's property, Jim Cook puts Bobby Atwell on the Frank Carson property, but now they're saying that it was 3 degrees out of the property, or in the area of the property, I should say. It puts it 3 degrees out, but that could actually be up to, with a 10-degree overlap, 13 degrees out of the property, out of that sector. That would show that gives Baljeet Atwell an alibi. He could not have been on the property. And it's a built-in alibi is what he's saying. The statutes show that there has to be, they have to show danger, that the withheld information has to be provided 30 days within trial or immediately then over. This was not done. Marlissa Farah was on notice how important it was. It was, and it proves that Bobby Atwell was not there. The DA could have forwarded this email to avoid these issues. Could have sent it out to everybody. Marlissa Farah went out and checked it on August 21st after defense cross. Marlissa on 8/22. Her questions were designed to protect Jim Cook's perjury testimony. Jim Cook wanted to show the defense his mapping was accurate, but showed the opposite. Jai Gohel did advise a court that Jim Cook needs an attorney for the possible perjury charge because he had in fact perjured himself. Jai Gohel says the defense could have been able to nail down Jim Cook had he been, because he had been lying many times, and they would have been able to prove it to the jury. But Marlissa Ferreira doubled down and did not say anything the whole day. He said he mentioned Robert Woody, who in his testimony, and it is what it is. Jim Cook is an expert, and the defense could have been, this information could have been a nail in the prosecution's coffin. But the DA sat quietly while Jim Cook evaded questions. The DA redirected Jim Cook again, asked him questions again, and still did not reveal the information. And then turn around the next day and turn that information over the next morning. The history of the DA conduct in this case shows violations of due process, and it should be a mistrial with prejudice and send everybody home on this thing, get it over with. We took a break, and we came back from break, and Judge Iniga asked one question actually of Marlissa Ferreira. She says she did not file a declaration on what had happened. The DA said she had disclosed the court, and she sent a email. When she received the email, she didn't know what it was, and she saw it about an hour later after it was sent, and she did a statement of facts on that and what happened the next day, the following days. Marlissa Ferreira says she saw, she checked the record when the attorneys did cross and asked them if there was a map. Judge Iniga stepped in and said, was there a map attached to that email? And she said, yes, there was. She just happened to, but she didn't look at it closely. She didn't think that much about it until in cross the next day when the attorneys were checking or doing a cross and talking about Google Maps. And she said it dawned on her later on that day. She was going to just rest, but went in to redirect again, but was concerned about the maps. He was concerned about the maps and never called Jim Cook that night, which meaning the 21st or the 22nd. She called him on the 23rd in the morning before court. She said she was on her way into the office and called him and told him to be in court. And she said, showed the defense she was making him available to be cross-examined. The DA admitted she had a date wrong when she originally addressed the court in the chambers, and she said it was the 22nd when she received it, but it was actually Tuesday, the 21st, when she got it. A statement of facts has been filed, talking about. She talked about the Brady information, and the defense must show three things. The evidence is favorable to the defense. The state suppressed the evidence, and prejudice ensued. And she says prejudice has not ensued here. She says absent outrageous conduct in this case, using Google Maps will not come up during all testimony. Only when it was on August 21st, 2018 is when he was asked about Google Maps. Jim Cook asked if he was asked to look at maps, and said Jim Cook never said no sir, or used Google Maps. No sir, never used the tool. And that was his testimony. She's saying that he said in court, he never used the software. No sir, never. She again was talking about some Brady, and the process is applicable to Brady information. And she says that defense says it's suppression and causes prejudice. She says none of that has occurred. Reading case law about discovery and suppressed or not, she says the defense has had ample time to research, follow up, to research and follow up. It does not lead to reversal. The prosecution cannot produce false evidence. She says, in regards to not being able to, can't produce false evidence, in referring to transcript of Jim Cook, she did not know at that time Jim Cook information was not accurate. Defense already knew the property was outside the sector, so they were already aware they could have called their own expert. So she then brought Jim Cook in again on the 23rd. She keeps saying the defense, but there's a jury there that got a little misrepresentation there. She had to look at the questions that were asked, determine if it was turned over properly or not. She again reading case law, and the prosecution has an obligation to turn over, and she said that is what she did. Reading again Jim Cook testimony, saying he didn't lie. He wasn't directed by Marlissa Ferreira to say anything or do the maps itself. She says she has not suppressed or denied anybody's due process rights. She says there was ample, vigorous, aggressive, and demeaning cross-examination of Jim Cook, and the defense has ability to call Jim Cook back in their case in chief. Two were finished with a cross. It would not have, and she would not have changed. It would not have changed their cross. She says they didn't cross Jim and Cook on this issue. Yes, they did. That's the whole issue here. And the defense is not citing any type of case law or anything specific about this all argument and no facts or case law. Again, she started reading some case law about turning over discovery right away. And she said the defense argument of her objection she made, but that is not exculpatory, and she has every right to object and she gives a legal basis why she has to object. So the defense was saying that her objections were trying to deflect away from the issue at hand, but she has a right to object, is what she's saying. Percy Martinez gave no citation of his arguments. Jai Gohel asked if he was, if he used the software to check his work, and the DA had asked him to check that night when they were at her office. Again, she says Jim Cook is available to call back. Defense trying to distract from the real facts. Defense claimed that the delay of discovery, but says it actually brought more, the way it happened has brought more attention to the issue, not deflect away from it. She says that the 3 degrees is subject to interpretation and depends on vacillations and obstructions. There's been no suppression under Brady. Defense claims that he lied, but they can't prove it. It's all talk. It is not a valid argument. Arguments have not been based on facts. The DA says Jai Gohel, again, the property, Jai Gohel was saying, again, the property was outside the sector. They already knew that. They were aware of that, so it's not new information to them. And she says there's no denial of that. So there was no due process violations or prejudice. Using on redirect, Dee noted that Jim Cook was not done on redirect. She started to talk about that, and Judge Zuniga interjected that he was not done on redirect. She was asking him more questions and stuff, and the DA says, well, no, he was done. She also, DA in good faith, she brought him back. She brought the information out on the 23rd, which was a Thursday. She also cannot provide at all that she brought it up. She didn't have to provide it. She could have just withheld it and not done anything, but she did bring it up in good faith. Percy Martinez objected that she was misstating some of the facts of the case and what she had declared to the court earlier. The judge says it's argument, let her finish. Defense is arguing, the DA went on to say, Marlissa Ferrer went on to say the defense is arguing, the argument is all speculation due to they don't know what happened. In regard to the 87 recordings that were not turned over previously in December of 2016, which led to the release, not all recordings were disclosed were actually recordings. There was only like maybe 2 recordings, and the rest were reports of knock and talks and those type of things. Non-disclosure is not prosecutional misconduct, and Z has determined that to be true because she took no action against the district attorney's office. So whatever Marlissa Ferrer did was not held against her by the judge, and so she's saying she didn't do anything wrong because the judge didn't impose any sanctions. We were done for the release for the lunch hour. Judge Inigo went off the record but was still talking to attorneys about some issues, and she ordered everybody out of the courtroom, said she wanted to give her bailiffs a break, so she ordered the public out of the courtroom. So I guess it's not an open courtroom anymore. They were still talking issues even though they were off the record. So it was a very strange thing for the judge to do. So that was it for the morning session. We come back in at 1:30. The attorneys still got to finish their arguments. And so I'm not sure we'll get a jury in the courtroom this afternoon. Don't forget the podcast tonight at 6 p.m. right here where you're listening to the podcast now. And I will put the audios back up on my site when I have an opportunity like I did before.